Um, okay, so Ms. Dugas is on probation for the offense of robbery, a second-degree felony. We were previously here, and she entered pleas of true to counts 1 through 12, all of the counts in that motion, second amended motion to revoke unadjudicated probation. I received the updated pre-sentence report as well as a letter from Ms. Dugas. Has everyone had an opportunity to review that? Are there any additions or corrections?
None from the defense, Your Honor. No,
All right, and this was unagreed, correct? Ms. Holmes, you may proceed.
Thank you, Your Honor. I've spoken with Ms. Dugas. Obviously, the various new offenses and violations is not acceptable through probation. She understands that. She stated that throughout this time, she did not have much support. She was going through a hard time in life, and she resorted to doing and committing these offenses. Not being in obviously the right state of mind to be able to successfully complete probation. Ultimately, Ms. Dugas is requesting to have the opportunity to be reinstated to complete probation, and she would like to address the court in regards to this as to her plan of how she can successfully complete if given the opportunity.
Okay, go ahead.
There you go, Miss West. Complete this probation. I know it's gonna be extended if you do gratitude. My name is John. I'm great. I'm being like I don't my will never be found the world.
Ms. Dugas, you did the exact same thing. You robbed someone else while you're on probation for robbery. Not just rob someone else, you failed to ID, failed to report to probation, you committed the new offense of possession of a controlled substance, you resisted arrest I- it's ridiculous to me that you're saying you want a second chance because this was your second chance. You've already been on probation. You were given the second chance of not going to prison. The fact that Miss Holmes negotiated a cap of 8 years for you, you should thank your lucky stars. This is ridiculous. 8 years, in my opinion, is not enough. You had every opportunity to do all the things that you're taught. Stop crying because you weren't crying when you were robbing people and using drugs and not being a good mom and not doing the things that you should have done when you were given this opportunity. Right? Miss Malfino? Sorry.
I don't think I need to add anything to the court. I think that you follow the agreement that age at the very least is appropriate for her based on the number of violations. I spoke with Mr. Chen yesterday. He does not want to continue to work with her. This is actually her third MTRP. It's about her fifth chance in front of you, not just her second chance in that quarter. So
Ms. Dugas, I'm going to find that you entered your pleas of true to counts 1 through 12 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time, find you guilty of robbery. Going to sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk to Ms. Holmes. I hope you take some advantage of this and actually do what you're saying you're going to do when you get out and change your life. There's programs in prison, take advantage of them, but you're not going to continue to get opportunities like this. If you continue to violate the law after this, you're going to be considered a habitual offender. And if you do anything again, your minimum punishment is going to be 25 years. 25 years minimum for what you've been doing. So you need to change your life or you're never going to see your kids, right? Go back with the bailiff. Good morning. Are you Wesley Antoine? And Mr. Antoine is here for sentencing on probation a deferred probation for aggravated assault, family violence, and that was a 10-year deferred probation that he was given back November 14th of 2023. Entered pleas of true, it looks like, to counts 1 through 11 in the motion to revoke unadjudicated probation. I've received an updated pre-sentence report. This was an open plea to the court. Is that correct?
Yes, Your Honor. The court had previously, when we were here before, it advised the court, that he received 4 months on that new case in Louisiana, but it does involve the same victim, Miss Red, as his case here.
Mhm.
We had discussed 6. The court did not feel comfortable with that, so we just decided to go on to you.
Okay. All right. So that's what, and I wanted to remind myself, I had a notation on this about that new offense. So the new offense was in Louisiana, and it was domestic abuse, battery, also by strangulation, correct? Against the same victim. All right. Mr. Lewis, you may proceed.
Judge, in this situation, of all my conversations with Mr. Antoine here, a lot of his issues come back to his mental health problems. And at the time, I believe he was not really open about getting the help that he needed with these issues. And once he got on probation, of course, those issues took over where he became in a very unstable situation. He admitted that he was homeless for a period of time there, which why he went back to Louisiana. All of his family is there. We had some sort of support system. And but Judge, he understands that he did mess up. He understands that, he hasn't done what he needed to on probation. He's taken it out for it. And he's just, at this point, he's asking sure for any consideration possible for so he can get out.
Thank you, Mr. Lewis. So on that original pre-sentence report, and the orders that went along with that, I mean, this is a first-degree felony. So on that deferred probation, it specifically ordered all the things that Mr. Lewis is asking for now. You've already had access to all of those things. To be placed on the specialized mental health caseload, to get an evaluation and get any type of help and treatment that is available. You were ordered to do those things. And in fact, what you pled to on this motion, true, is that you didn't get the evaluation completed. And so you never were able to get services. And that was your choice. Everything was given to you. You had all the opportunities in the world to get whatever help you needed so that you could be successful. But the fact that you're on probation, I mean, the allegations in this underlying case is that you had a cane and that you just beat the crap out of Miss Red with that cane while she's on the ground. And then you get out and you get around her again and you strangle her. I mean, it's just beyond me. That's where what you would do. I mean, it sounds like if the go to Louisiana, if you have support, that's great. But to go back and do that to her without permission, without you, I mean, you weren't working, you didn't have your mental health, you didn't do your community service, you didn't do the batterers intervention prevention program, which probably would have taught you how to not beat on and attack and put your hands on people that you supposedly care about. Got a new offense over there for that. Anyway, I'm going to find that you entered your pleas of true to counts 1 through 11 freely and voluntarily. I'm going to find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault on a family victim. I'm going to sentence you to a term of 15 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody, that the laws give you the right to receive. I believe the initial was yes. I am going to make the finding that there was a deadly weapon in that initial case. I'm going to hand you the trial court certification. You need to sign this with Mr. Lewis. It shows that this was not a plea agreement. You have some rights to appeal. You can talk to him about that. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk to Mr. Lewis. Good luck to you, sir. Sign that, and then you can go back with the bailiff.
This courtroom hearing featured two defendants whose repeated probation violations convinced the judge that they had exhausted every opportunity the justice system had offered. Both entered the courtroom hoping for another chance, but after reviewing their criminal histories, probation records, and repeated failures to follow court orders, the judge concluded that prison, not probation, was the only remaining option. The first defendant, Ms. Dugas, appeared before the court after previously admitting to 12 separate probation violations connected to her deferred probation for robbery. She had originally avoided prison by receiving probation, giving her an opportunity to rebuild her life outside of custody. However, instead of taking advantage of that opportunity, she repeatedly violated the conditions of her release. Her attorney acknowledged that the violations were serious but asked the court to reinstate probation. She explained that Dugas had gone through an extremely difficult period in her life and lacked support from family and friends. According to the defense, those hardships pushed her toward making poor decisions and committing additional crimes. The attorney argued that Dugas had learned from her mistakes and wanted to explain to the court how she planned to successfully complete probation if given another opportunity. Before Dugas could continue, the judge interrupted. The judge reminded her that probation itself had already been her second chance. Instead of using that opportunity wisely, she committed another robbery while already on probation for robbery. She also failed to identify herself to police, failed to report to probation officers, committed a new drug offense involving possession of controlled substance, and even resisted arrest. To the judge, these were not small technical violations. They showed a complete disregard for the trust the court had placed in her. As Dugas became emotional and began crying, the judge remained firm. She told her that she had not been crying while robbing people, using drugs, or neglecting her responsibilities as a mother. The judge explained that sympathy could not erase repeated criminal behavior. The prosecutor agreed completely with the judge's assessment. He pointed out that this was not really Dugas's second chance at all. According to probation officials, she had already received several opportunities through supervision and rehabilitation, yet she continued making the same choices. Even her probation officer no longer believed she was a suitable candidate for continued supervision. After reviewing all the evidence, the judge formally accepted Dugas's admissions to all 12 probation violations. She revoked her deferred probation, found her guilty of robbery, and sentenced her to 8 years in the Texas Department of Criminal Justice. Although the sentence matched the negotiated cap previously discussed, the judge made it clear she personally believed 8 years was extremely lenient considering everything that had happened. She warned Dugas that once released, she would never receive another opportunity like this. If she committed another felony after prison, Texas habitual offender laws could require a minimum sentence of 25 years, meaning her future freedom depended entirely on changing her lifestyle. The judge encouraged Dugas to participate in every rehabilitation and educational program available inside prison. She explained that this sentence should become a turning point rather than the beginning of an endless cycle of incarceration. Most importantly, she reminded Dugas that if she truly wanted to see her children again, she would have to prove through her actions, not her promises, that she had changed. The courtroom then moved to the second defendant, Wesley Antoine, whose case involved an even more violent history. Antoine had originally received 10 years of deferred probation after being charged with aggravated assault involving family violence, a first-degree felony. Like Dugas, he had already admitted violating numerous probation conditions. His attorney explained that Antoine struggled with severe mental health issues that affected nearly every part of his life. According to the defense, he had been homeless for a period of time and eventually returned to Louisiana because his family lived there and could provide support. The attorney argued that Antoine finally recognized his mistakes and simply wanted another opportunity to receive proper treatment. The judge carefully reviewed the original probation order. She immediately pointed out something extremely important. Everything the defense was requesting had already been provided. When Antoine originally received probation, the court specifically ordered mental health evaluations, counseling, specialized supervision, and every available treatment service. Those resources were waiting for him from the very beginning. The problem was not the lack of help. The problem was that Antoine never completed the required mental health evaluation, and therefore never followed through with the treatment that had already been arranged. According to the judge, every opportunity had been placed directly in front of him, but he chose not to use any of it. She then turned her attention to the facts of the original assault case. Court records showed that Antoine attacked the victim with a cane, repeatedly beating her while she lay on the ground. Even more disturbing, after receiving probation and being ordered to stay away from the victim, he traveled back to Louisiana and committed another violent domestic assault against the same woman. This new offense involved domestic abuse by strangulation, making the judge question how someone could continue attacking the very person they claimed to care about. The judge reviewed every probation violation one by one. Antoine failed to obtain his mental health evaluation. He failed to complete community service. He failed to attend the Bachelor's Intervention Prevention Program, a course specifically designed to teach offenders how to stop violent behavior in relationships. He remained unemployed. Most importantly, he committed another violent offense against the same victim while already on probation. The judge explained that mental health struggle could never excuse refusing every opportunity offered by the court. She believed Antoine had been given every possible resource to succeed, but